Court calls the people of the state of Michigan versus Philip Andrew Liefers, case number 26819FY. Appearances, counsel.
Please sit all for the people.
Good afternoon, Your Honor. Bernard Jockins appearing on behalf of the defendant, Philip Liefers.
So are you Mr. Leffers?
Are we on the record, Your Honor?
We are. Are you Mr. Leffers? Is it Leffers or Liefers?
I am Philip-Andrew Liefers. Being duly sworn, hereby declare my intentions to be a Michiganian national by birth, but not a citizen of the United States. I am here on special appearance in this case as authorized representative, beneficiary of the estate of Philip Andrew Liefers. I appear before this court without waiving any rights, claims, defenses, or remedies available to me at law, equity, or under trust or fiduciary law. I have my CPAS.
We can't really hear you.
Sir, can I get you to speak up so that
Yes,
so that we
sorry,
can get a
sir.
clear record?
I have my CPAS. I have been working very hard to understand and overstand a lot of things in the past. No disrespect, just complete forwardness. I move the court to take judicial notice of the Michigan Constitution of 1850 and the United States Constitution of 1788. And your oath to it, sir.
The yes or no to what?
This is a copy of your oath of office, sir.
I don't take anything until judge tells me to.
Bailiff, I'll take it.
Yes, sir.
Yes, that is my oath of office and has my signature on it from January 22nd, 2025. You can hand that back to him.
I move the court to dismiss this case per canon 2057, which states any administrator or executor that refuses to immediately dissolve a Sesta QB trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. And per the United States Constitution, Article 3, Section 2, Clause 2, clearly states that when the state is a party, whether defendant or prosecutor, the Supreme Court has original jurisdiction. Supreme Court decision 1796. There every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Pruden v. Neely, 2 NC 338, 1796. And don't forget the law of the land, where the general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 2 Cronch 137, 174, 176, and 1803.
Laddies and gentlemen, buckle up, because today's courtroom encounter is one of those cases where the legal system collides headfirst with internet legal theories. What starts as a routine criminal hearing quickly turns into a marathon of constitutional citations, misunderstood court precedents, and arguments that leave even the defendant's own attorney questioning how much more of this he can take. The man at the center of today's case insists he is not subject to the authority of the court in the way most people are. He claims special status, challenges jurisdiction, invokes centuries-old legal concepts, and attempts to dismantle the entire foundation of the proceedings before the hearing has barely begun. But here's where things get interesting. While the defendant appears absolutely convinced that he has uncovered hidden legal truths, the judge and defense attorney are focused on a very different issue: whether he actually understands how the legal system functions well enough to represent himself. As the hearing unfolds, you'll watch the court struggle to separate sincere beliefs from practical legal reality. You'll also witness one of the most awkward attorney-client relationships imaginable, culminating in a moment where the defense lawyer essentially tells the court that communication has completely broken down. Keep an eye on the judge throughout this hearing. Rather than reacting emotionally, he carefully allows the defendant to speak, listens to the arguments, and then begins asking questions that cut straight to the heart of the issue. By the end of this case, the discussion won't just be about constitutional rights or jurisdiction. It will become a debate about competence, self-representation, and whether someone's confidence in their own legal theories can actually work against them in court. And trust me, when even your own attorney starts objecting to your arguments, you know things are about to take a very unusual turn.
And where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, page 491. The United States Supreme Court has repetitively held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. versus Will, 499, U.S. 200, 216, S period CT period 471, 66 L edition 2B, 392, 406, and 1980. I, Cohen versus Virginia, 19 U.S. 6 Wheat, 264, 404, 5L edition 257, 1821. 5 U.S.C. 556D, 557, and 706. Once due process is denied, all jurisdiction ceases. Due process has not been properly followed on me. I have not been given full disclosure of everything, including the accounting information, the bid bond, the performance bond, the payment bond, all accounting involved in this, as well as I have not been given the almost 1 hour video of the security footage from Save-A-Lot. Only 14 seconds is what I was informed from Mr. Jockins, and when I asked him for it, he denied me access to it. So I am not being given a fair shot. So I have removed him as my counsel.
Judge, I can't see Mr. Lepers in there. I don't know if the court wanted me to respond.
Sure, let me adjust the camera. I'm sorry for that.
Your Honor, I'm just going to back up and give a little bit of procedural history to the court. I know that the court always reviews the files. I'm just going to explain where I'm at. When I was initially assigned counsel on this case, I took the time and opportunity to review Mr. Lepers and consult with Mr. Lepers, not in person, but I did. With that information that was provided to me and speaking with other witnesses, family members, potentially, I decided it was appropriate to file a motion for a competency evaluation and inevitably criminal responsibility in this action. And the court could take notice to the Mr. Leffer's remarks, motion, etc. Judge, I provide everything, to Mr. Leffers, as I do for all of my clients, and I do follow the Michigan Constitution, the United States Constitution, and every case I have is as important as anything that is going on. With that in mind, Judge, I got notice of this was supposed to be, I believe, on the 7th or 8th of April, and I had contacted the clerk indicating that I didn't think that it was appropriate at that time because we still do not have the evaluation that was returned from the MDHHS regarding the forensic evaluation. And maybe the court can understand the reason why I requested this evaluation, regardless if something was like a ChatGPT sovereign motion. If the court wishes to remove me, I am fine with that. If somebody doesn't want me to represent them, that's fine. But at the same time, I meet all of my obligations and do everything that I am supposed to do with each client, even more so.
Yeah, I don't blame his lawyer for wanting to run away as fast as possible from the sovereign citizen superglue buffet.
So with that in mind, Judge, the only concern that I have is that we're still waiting on a forensic evaluation that Mr. Leffers had participated in approximately a calendar week back.
We got the motion for that, order.
Yeah,
What did I do a calendar week back?
I don't show where I see where, at least I can't put my hands on it now, but I remember you filing a motion, but I have not signed an order for a competency evaluation yet.
Well, with that in mind, Judge, I don't know what the court would like to do. If the court would like me to get, I thought that I had provided a competency order, SCAO form. If not, Your Honor, I'm fine with Mr. Leffers proceeding on his own.
Your Honor, I object.
Hold on. Yeah, so I show that there was a motion filed by Mr. Jawkins on March 23rd for motion for evaluation of defendant's competency to stand trial. And actually, I believe it was that same day we received the defendant's motion, Mr. Leffers' notice of self-representation and motion to withdraw. And then the next day, we received an updated copy of that notice of self-representation and motion to withdraw. So I believe this is the first time we're here since these have been filed. And it's generally the court's practice to have a hearing before just granting a competency request. So that was one of the reasons we were here today. So we were actually set for a preliminary examination and these motions. So I believe it obviously is not appropriate to do the prelim today. And so that gets us to the motions. So I guess, Mr. Jawkins, I'm going to turn to you quickly. Your take on the situation. I know you said that you are okay withdrawing, but do you believe that there has been such a breakdown as to require you to withdraw?
Your Honor, I cannot communicate with this individual, and my apologies. When I had communicated with the clerk's office, I was it was indicated that the exam was taken off the docket, and that might have been an email thread as well. So I hope the court doesn't think I'm being deliberately derelict or anything like that. But
no,
these are the reasons why I filed this motion, Judge. But if Mr. Levers would like to proceed on his own, I'm not interested in. I'm the captain of everyone's ship, and I leave it at that. I don't have a good feeling about that when someone files a motion to withdraw, and if I am out there. However, I still think it's appropriate for a competency evaluation, because that's the reason why I had filed that, Judge.
All right. Thank you. Now, Mr. It's Leffers or Leafers? I know you said and I apologize.
No,
So I want to make sure that I'm following your request. And I understand that you have some arguments as to, one, whether or not the court has lawful jurisdiction, lawful authority, and also a question of whether or not you have been provided with appropriate due process. Couple that with is your request to represent yourself. Am I correct on that?
yes,
All right. And are you requesting to represent yourself?
yes,
You do understand that you have the right to have an attorney that either you could hire or that the court would appoint, as opposed to you representing yourself. Do you understand that?
yes. My creator has placed a lot of friends around me with wonderful information that I never knew. And I'm grateful to know this now. I'm sorry for being caught in dishonor in the past. It will not, Yahuwah willing, happen again.
Well, apparently, it's already happened again. Allegedly.
I understand my place, and I have always tried to respect the way that things are, which is why I need to finish this as well, sir, please.
Go ahead.
And with discovery not being met, there are no medical records, let alone a psych evaluation proving any type of trauma. No harm has been done. No pain has been inflicted and no property was damaged. I have entertained the contract deal of alcohol testing, and I don't drink anymore. Yeah, that was an issue. Not anymore. But in the same token, I can no longer contract with it, knowing that everything's a contract. As you can see from the tests, I even stopped smoking weed and only smoked it right before bed. Since the motorcycle wreck, things have been very uneasy trying to sleep at night. Period. Definition of presumption. An idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge. That presumption, the presumption, then has no standing or merit in fact. Probability. The extent to which something is probable, the likelihood of something happening in a case. A definition then, this is not substantive, as it is only a probability of what may be, and therefore has no substance in marital fact. An incorporated state court does not operate according to any true rule of law, but by presumption, color of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, and are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor, beneficiary, agent and agency, incompetence and guilt. Section I, The presumption of public record is that any matter brought before a state court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is private bar guild business matter, unless stating openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under private bar guild rules. I, Philip Andrew Leifert, is the undersigned formally challenge the presumption of public record, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section 2I. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public